Okay, welcome everyone to our another one of our webinars, the Community Legal Centres Queensland webinar series. Today we are looking at helping clients with enduring powers of attorney. So firstly, I'll just acknowledge the traditional owners of the land on which we are holding this webinar. So in Brisbane, they are the Turrbal and Yagara people, and I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. So as we've got viewers across Queensland and the country, I'd like to also acknowledge the first Australians from the regions in which you're viewing the webinar. What we'll do first is just go through some housekeeping and make sure everyone can hear and see the webinar, and then I'll hand over to our presenter. So my name's Carly from Community Legal Centres Queensland. James is away, so I'm running the webinar today. So let me just go through my notes. Okay, so today we'll be recording the webinar, and hopefully you would have already received an email which linked to the PowerPoints and the other materials that we've got on our website. And when we finish the webinar, we'll upload the recording to the same spot as well. So if you want to ask questions, there are two ways you can ask those. You can press the button that looks like a hand and we'll see a hand go up at our end, and then we can unmute you so you can ask your question via the microphone. Or the easier way, you can just type your question into the question box on the control panel and we will read your questions out at the end and give Karen a chance to answer those. So what I'll just get you to do is press the button that looks like a hand just to make sure everyone can hear before we hand over to our presenter. Great, I can see some hands going up there, which is fantastic. So it sounds like everyone is on board and can hear. So again, today we're just looking at helping clients with enduring powers of attorney. So presenting for us is Karen Williams from ADA Australia. ADA Australia recently completed a project about enduring powers of attorney, developing process maps, training videos for attorneys, and intake proforma for community organisations. Karen will provide an overview of this project and how community legal centres and other community organisations can assist clients to navigate this system with these helpful resources. So without further ado, I'll hand over to Karen. What we'll probably do is just take all the questions at the end. And so, pop your questions into the question box and we will get to them at the end of the presentation. We also are going to be playing a video today, so we'll see how that goes with the technology. Sometimes there can be slowness depending on the internet connection. If too many people are experiencing problems, we'll just sort of hold that video over and make sure you can access the link and watch that one in your own time. Okay, thanks very much everyone, and take it away, Karen.
Okay, thanks very much, Carly, and good afternoon to everybody. Yes, today essentially we're just looking at the resources regarding enduring powers of attorney that we're able to complete. So I'd like to thank Vivian Boyd, who is the project officer and who's now on leave, lucky her. And also these resources were completed with the assistance of a range of organisations which we'll go into. So essentially the reason for the development of the resources was that we were noticing there are lots of various questions with various degrees of difficulties around enduring powers of attorney, and we're just trying to provide some simplification and clarity for community organisations. Okay. I too would like to acknowledge the traditional owners of the land in which we're holding this webinar today, in Brisbane in particular, the Turrbal and Yagara people, and I wish to pay my respects to elders past, present and emerging. Okay, thank you. Okay, so the resources essentially are around assisting people who are acting as an attorney, how to fulfil their role and meet their obligations, or even to draw their attention to the fact that they do have specific obligations in a particular role. So We are going to play the video now, which sort of sets the scene. We're very much guided as again by the stakeholder group. So I'll just see if we can get this video started.
Being appointed as someone's attorney under an enduring power of attorney document means that person has placed their trust in you to make decisions for them if they are unable, such as if they become sick or injured. You may be required to make small or very large decisions. Your role is to make the same decisions the person would have made themselves. It's a bit like standing in someone else's shoes. Even though the role is voluntary, it still carries strict legal and ethical responsibilities. That's why it's important that you fully understand your role. This video will guide you on how to act appropriately as an attorney in Queensland. Before you start making decisions, read the Enduring Power of Attorney document carefully. This will outline what decisions you can make, how to make them, and when you must do so. You have the responsibility to make these decisions, but not a right to control the person's life. You may be appointed for financial decisions, such as paying bills, personal or health decisions, such as organising doctors, or you may be appointed for both. The person may also have other attorneys. In this case, the document will tell you how the decisions are to be made between you. They could be made jointly, severally, or separately, as a majority, or in a successive order. The document may also include special instructions or terms to follow, such as how to manage investments, directions about personal matters such as people they do and do not want to have contact with, authority to make specific transactions. Your duties as attorney don't automatically start as soon as you accept the role. Depending on the document, you may be required to start making decisions immediately, on a certain date, or when the person loses capacity. Before you make any decisions, you must always consult the person first, as their views and preferences should lead the way. Sometimes you may need to provide information to help the person participate, or you may need to look into their past choices to inform yourself of what they would want. Any decisions must be for the person's benefit, and not to satisfy your personal preferences or for the benefit of anyone else. These decisions can be challenging, so we have outlined 6 key considerations to guide your decision-making. 1. Capacity for decision-making. Your role is to encourage the person to participate in decisions that affect them. The law presumes every person can make their own decisions until it is clear that this is no longer the case. If you or others have concerns about the person's decision-making capacity, it is your duty to organise a formal assessment with a health professional to identify which decisions they can and cannot make. Most people are still able to make some decisions for themselves. You can only make decisions for the areas the person no longer has capacity for. For example, they may lose capacity for financial decisions, but retain capacity for decisions about living arrangements. 2. Respect rights and needs. All people have the same basic human rights which protect their individual dignity regardless of their abilities. A loss of capacity does not change a person's right to be valued and shown respect. You need to respect the person's rights, values, safety, health, well-being, language, culture, and religious beliefs. The consequences of any decision should preserve the person's independence while being appropriate to meet their needs. The person should be encouraged to be as self-reliant as possible and to participate in community life. This includes keeping their existing friendships. 3. Communicate with others. Communication will be a large part of your role, and your main communication will be with the person. If there is more than one attorney, you always need to consult between yourselves when making decisions. It's your job to ensure that you gather as much information and insight as possible so that you can make informed decisions that accurately reflect the person's views and current needs. Others can assist you by providing valuable information. These may be extended family, close friends, health, financial or legal professionals. This can be difficult as you may not share the same close relationship with these people. However, you cannot cut off these key people or withhold basic information from them about the person. You must ensure the person's right to privacy by only talking to people relevant to the decision to be made. Keeping relevant people informed about key decisions will also reduce the chance of problems arising later. 4. Manage money and property carefully. If you are making financial or legal decisions, you must remember that it's not your money or property. Decisions you make must only benefit the person you are making decisions for. You are required to keep the person's money and property separate from your own or that of other attorneys unless already jointly owned. Act carefully and diligently with the person's money and property, even for small amounts. Keep accurate records of financial or property transactions you make. Obtain financial or taxation advice for decisions or investments. These costs can be recovered. Only invest in authorised investments. Avoid conflict transactions. Provide for the reasonable needs of a dependent of the person. Be aware your actions must be transparent and they may be questioned or challenged by others. 5. Avoid conflict transactions. The person's financial interests should always be your first priority. It is important to be on the lookout for any financial decisions which may directly or indirectly benefit someone other than the person you are making decisions for. This may include actual or perceived benefits to yourself, other attorneys, relatives, friends, or business associates. These are called conflict transactions. Examples of this might be selling the person's home below market value to your relative or friend, unusual gifts of money, or starting a joint account without authorised direction. When holding existing property and finances in joint names with the person, you will need to seek advice from your solicitor or the Queensland Civil and Administrative Tribunal before making decisions. The person's financial interests should always be your only priority. 6. Keep the person informed. You will need to keep the person updated about decisions you make for them. This respects their rights and promotes a positive relationship. Keep them informed about bank balances by providing regular copies of statements, property sales or transfers, changes in contact information for friends and family, any other changes to their affairs such as having new service providers. Stepping into someone's shoes to make decisions for them is an important role. As you can see, there is a lot to think about when making decisions. You need to be sure that any decisions you make link back to making the person's life better. For more information, you can access the following resources.
Okay, so that's the video that's available on our website, and then you'll have in the materials the YouTube address for that as well. So why were they needed? Well, you can see from the video that we tried to clarify the role of attorney, and it answers many of the inquiries that we'd have through our intake service, and that's been reported in the legislation. There's a lack of accessible education to assist attorneys, and everyone will say, well, if you read the document from woe to go, there's nothing new in the materials, but the difficulty has been that people don't actually read the document that they're signing, and there seem to be many community organisations as well as government agencies approached for assistance, and stemming from a lack of understanding of the document and the duties in the role. The resources, as previously mentioned, were funded by Department of Justice and Attorney General, and they were launched by the Attorney herself a couple of weeks ago. And the result of about 6 meetings from our steering committee, experts, and they were extremely motivated, and we're very grateful for their input. So included in the membership of the steering committee is Seniors Legal and Support Services, Queensland Advocacy Incorporated, and Law Right, formerly QPILCH, and ourselves. And also from the government agency perspective, we had Public Trustee of Queensland, the Office of the Public Guardian, particularly their investigation section, who received many complaints about the actions of attorneys, and the Office of the Public Advocate. Okay, as you can see here, just stepping you through how to access the resources. So from our website, if you go to the Resources tab, scrolling down to Enduring Power of Attorney, as you can see, and there's the box highlighted at the bottom right-hand side of the screen. So that includes the video as well, which we've done. Okay, so we developed some flowcharts, which is on that resources page. The purpose of the flowcharts, in that when we were having discussions within the steering committee, is lots of points about the problem with enduring powers of attorney is this, that, or the other thing, and people were talking about different points in the process that were difficulties, and I thought, well, one of the easiest ways is to try and clarify or pinpoint where people were experiencing the difficulties, so we reduced that to the flowcharts. There's a couple of flowcharts. The one that you see on the screen now is the overall or overarching flowchart, which is about making an enduring power of attorney, which may start with a prompt, which could include visiting a solicitor to complete a will, and someone might say the solicitor may prompt them to consider an enduring power of attorney. Then the next step is seriously considering it, including any particular terms and considering when it might start, what evidence is required, and think about terms regarding consultation or communication, conflict transactions, and the like. Then there's the execution section, and there was a lot of discussion there on the third box around what particular education may be required in the future for people executing documents. We've already had from JP branch a lot of interest around these materials. We have the acceptance, then the finalisation of a valid document, discussion about certified copies, distribution of copies. So these are prompts for people. And then the next box down, which you can't see on the screen at the moment, is change of circumstances. So if your circumstances change regarding yourself or your attorneys, that should prompt you to review your document. These including marriage or remarriage, divorce, a conflicting document. Someone might execute an advance health directive, and then the enduring power of attorney may no longer align with that document. The attorney may withdraw whilst you've got capacity, which is fairly simple, or becomes a health or a carer, paid health or paid carer, becomes bankrupt, or the attorney may die. So they're all obvious change of circumstances which go back to having a review of the document, which is a point 7. Okay, on the next flowchart becomes a lot more intricate, and there was a lot more discussion around this. So there's on the number 2 is making and using an enduring power of attorney. So this happens when there's a question mark over someone's capacity. Someone requests the document. So increasingly, for example, entry into any aged care, whether it be community-based care or residential care, people will request an enduring power of attorney, or there might be concerns about the principal's capacity to make their own decisions. Now, a lot of these steps are quite obvious, but the difficulty is that not everyone knows what the obvious steps are. So it's just there to prompt and remind people. So, for example, reading the document and then identifying who are the attorneys for financial, personal health matters, and for financial, the consideration is this an immediate start document, or it starts at a specific date or event, or when there's a loss of capacity. The third box that you can't see on the screen, but I encourage you to have a look at these later or now while you've got them printed out, is that capacity is questioned. Sorry, we're getting ahead of ourselves here. Capacity questioned, formal assessment of capacity being required, and then there's various flow points from that about that the person's got capacity, or there's an application to QCAT around capacity, or they have lost capacity. So there's steps through. So the second flowchart is probably the most complicated. And then the third one, which we managed to fit entirely on the screen, is just based on the attorney has started to act. So they're either, 1, acting appropriately as per the duties and responsibilities, or they're not acting appropriately and there's a challenge to their action or inaction. This could be by the principal, other members of the family, other attorneys, a health service, or the public guardian by way of their investigations power. This could be informally resolved in that the attorneys just may need some education, which is what the literature shows. It's more that they lack the understanding on what their responsibilities are rather than they're necessarily setting out to do the wrong thing. And then the third option when they start to act is they may actually be unable or unwilling to act, and they may need to put an application to withdraw to QCAT. So there's a few points there where it goes to the tribunal. And the link to that is at the bottom of the PowerPoint there. Okay, so other documents, flowcharts are not everyone's cup of tea. So we've developed some other materials to support the flowchart and the video. So just looking at my duties and responsibilities as an attorney, and starting with the rights of the person, which is there on the screen. Underneath that box, so we're referring people to the general principles and the healthcare principle, which is the how decisions are meant to be made, but often people are in our experience, quite unaware of that. We've put a case study on the front, and the case study was supplied by the public guardian. And on the inside of that form, we have tried to put into plain English the general principles and the healthcare principle as well. On the back of that document, we've put a glossary to assist people in understanding terms that they may not be familiar with. So all of that is available for yourselves. So that's the general principles. The other thing to note is that the public guardian on their website have the general principles that are taken straight from the legislation, and they're very easy to look at rather than printing out the legislation straight up. Okay, in pulling all of these resources together, we've developed a proforma intake form, which is available, which you may or may not want to use. but in particular, we noted most of the calls that ADA was receiving were from third party and was more likely to be a family or friend or a carer or service or health provider. So it's good to identify the caller and their role in the situation in relation to the principal, or they could be the principal themselves. If it's a general inquiry, the first flowchart may be sufficient, or a specific inquiry, someone's asking for a document and trying to understand why someone else may want the document, can help to tailor your response. So that document has links to various parts of the flowchart, and in consultation with our intake advocates, we've sort of developed further down the bottom of that resource of the intake form some questions that people may want to consider, and tailoring it to the adult or the principal. And over the back there's questions for the attorneys, third parties, a prompt about mediation, other referral and resources, and other support organisations that people may be able to refer others to. So it's just a consolidation document and some prompts and some guides that people may use or may want to modify if that might be useful for you. Okay, so where to from here? So there's the steering committee that I spoke about earlier that was pivotal in providing lots of guidance and advice as we started to draft the resources is continuing. It's chaired by Malcolm Patterson, and it's just met this week actually as the first ongoing meeting from the end of our particular project. So we've handed off to Malcolm, who's the Senior Community Engagement Officer of the Office of the Public Guardian, and that enables collaboration and communication to continue between Seniors Legal Services, Law Right, QAI, ourselves, the government departments I spoke of, and also the universities, the University of Queensland and QUT are both interested and involved in this area as well. So there's keen interest in realising there's lots of organisations involved in improving people's understanding of what the document is and what assistance can be provided. Okay, in parallel to the development of the resources, ADA recently collaborated with QUT Health Law Research Centre and the Crime and Justice Research Centre regarding case analysis of past 120 intake calls and cases that went on to providing some services regarding alleged financial abuse and enduring powers of attorney. So the cases were de-identified and the literature review was completed, and the themes from the literature review were applied to the case studies and to see, what were the themes that were emerging from these cases, and probably be of no surprise. But in parallel to the project, there was identification of these key themes, that there's a greater education about EPOAs for principals and attorneys required. There's a lack of understanding of capacity, so when the document does and doesn't start, and it's interesting to note in relation to amendments to the Guardianship and Administration Act that capacity guidelines are now being proposed within the bill to be developed to assist people to have a better understanding of capacity and its assessment. And also a very much greater understanding of the impact of loss of legal capacity, and I think people who are very aware of the Rights of People with a Disability, the UN document, which is written often to address that, the loss of legal capacity and how that can be accommodated. I think in the aged care sector, it's not as well understood, that particular loss. And in particular, we would see many times that the day before someone goes into aged care, they're required to complete an enduring power of attorney, and then the day after they're there, the residential aged care facility has determined that they now lack capacity and they're only dealing with the attorney. So we see that time and time again, and it's very removes any agency that the adult has. Also, the consequences of failing to adequately assess capacity cannot be ignored by service providers and health professionals, which underscores the previous 2 points. And particularly in the case studies, even where quite significant alleged financial abuse was reported at referral to the service, what was critical to the person was their relationship with family or friends, people that they identified as supportive, and maintaining that and maintaining relationships as much as possible, and noting that the multidisciplinary responses are required, which once again won't necessarily be a surprise to anybody. If anyone's after that report, that's been provided to us by QUT, and we're hoping to have that up on our website in the same section shortly, but they have done an extremely thorough review, and that's the 5 key themes, but you can be able to read it at your leisure. Okay, so just to recap the key skills and responsibilities for an attorney. So the capacity for decision making, and also being specific to the decision that's to be made. Whilst there's general understanding of capacity, it's still seen very much as a global concept when it should be in respect to the question to be asked. So, for example, the QCAT hearing, the attorneys may have begun acting and making decisions, but QCAT member may say, well, the person's got capacity to decide who they wish to remain in contact with. Respecting rights and needs, we've addressed that in the material. Communicating with others is a duty of the attorney, in particular with the adult or the principal. 4 and 5 in relation to their duties, in particular with financial transactions. And 6, keeping the person informed. Many times a person may just want to access the bank account, not to make a financial decision, but just to be reassured that they have sufficient funds to pay bills. Okay, so for more information in relation to the materials, we have got the various addresses there, and also the QCAT address down the bottom, and QCAT are able to, through their miscellaneous application, respond to queries and hearings in relation to the enduring power of attorney document, the validity, and also if attorneys have begun to act in relation to the principle, that they need to seek leave of the tribunal to remove themselves as attorneys once they've begun to act, and that's a formal process through QCAT. Okay, thank you for your time, and we'll just check to see whether there's any questions, and invite you now to send any questions through.
Okay, so we've got a couple of questions that are coming through. Please feel free to send through some more. But the first one here we've got is just asking, Karen, when will the QUT report be available on your website?
Okay, so there was within the last week or 10 days, QUT held a function to launch the report, and there was a panel available. They have, as far as I'm aware, cleared us to lodge it on their website. They're going through the process of putting it on their websites, both the Health Law Research Centre and the Justice website. So it should be up within a week, and I'll ask one of our project officers who deals with our website to make sure it's up there.
Fantastic. So just another question that's come through. So I'm just going to read this one out for the benefit of others. So some attorneys may not wish to involve the principal about what steps they are taking on their behalf, being well motivated by not wishing to stress a principal. What could we as legal advisors say that could assist the attorneys with understanding the requirement to communicate with the principal?
Okay, that's an excellent question, and it's often something that everyone's aware of, and it's a very delicate balance. So one step might be to seek some, for the attorneys to seek, medical or psychological advice about how to inform the principal. So it starts with the duty that they need to involve the principal via the general principles, and to seek advice as to how best to put that communication with the principal, or it may be, for the safety and well-being in some extreme circumstances that's they're advised by a health professional not to release the information. So it needs to be, the message needs to be that it's the norm, or it's the basic practice that information is provided, but they may seek assistance as to how best to provide that information.
Okay, fantastic. Just check and see whether any other questions have come through. So just a reminder that if you do want to ask a question, just type your question into the question box, or you can press on the button that looks like a hand and we'll see a hand go up at our end, and we can then unmute you if you want to ask your question. Looks like we've got someone, oops. Okay, doesn't look like we've got any more questions there. I'll just double check. We've got a little bit of time left, so feel free, this is your chance. Okay, we've got someone here who wants to ask a question. Vanessa, I'm going to unmute you. Hopefully you've got a microphone there and we can all hear your question. So over to you. Are you there, Vanessa? Have you got a question? No. So we can't hear you, Vanessa. If you're speaking, maybe make sure your volume's up and your microphone is on and working. Otherwise, if you'd like, maybe it would be easier to just type your question into the question box on the control panel on the top right-hand side of your screen, and then we can read that out so that everyone can see the question there as well. Okay, there we go. So we've got a couple of questions here. So can we in Western Australia access the video shown earlier? So Karen, can people over in Western Australia access your video?
For sure. Just some points. It was written with Queensland in mind. Queensland are currently undergoing a review of the Guardianship Administration Act and the Powers of Attorney Act and the forms, which are the Advanced Health Directive and the Enduring Power of Attorney. actual form. Because they're under review, we didn't actually show the real live enduring power of attorney form because we were mindful that it would date the video immediately. Most of we're informed by basically trying to unpack the fiduciary role, which is a term that most people, if you stop them in the street, would hardly be able to say, let alone understand what that meant. And we're informed by some materials developed in United States and in Canada. So you can absolutely access the video via the website, and the earlier PowerPoints have the YouTube link if there's some difficulty in accessing it through the website. You can go directly to YouTube, and it's called Attorneys Acting Appropriately would be some search terms.
Great, and it is a really good video, very user-friendly. Karen, do you think that's something that, centres could show clients or
Absolutely.
would encourage clients to access? Great. Okay, so another question that's come through, or just following up from that, I think around the fiduciary role. So we've got a question here, or a comment. It is the fiduciary role that we want to emphasise in our community legal education sessions. So that's good, isn't it?
Absolutely, because it's assumed a lot in the legislation, and it's enduring powers of attorney come from the general powers of attorney, and it's a long established legal tradition, not well understood. We haven't really clarified that for people, and that's what we've attempted to do here, and hopefully over time we can add, and others can add to these resources.
Thanks, Karen. So last question that we've got for today, unless anyone wants to pop in an extra question. So how detailed does the formal capacity assessment need to be?
Excellent question. Unfortunately, there are no guidelines currently, but as I said, they're in the Queensland legislation, not in the legislation, in the proposed bill of amendments for the Guardianship Administration Act and the Powers of Attorney Act. One of the difficulties we have, particularly in relation to enduring powers of attorney, even though there's various conditions that people may put in the document, and there's different attorneys who may have different decision-making responsibilities, is that all that is required currently for an attorney to act is a one-line certificate from a general practitioner, which turns the document effectively into a very blunt instrument and doesn't require an assessment of capacity for the different areas of decision making. So it's certainly our recommendation in the development of these guidelines, if it goes ahead, that it be a lot more specific and at least covers the different matters that are listed in the Guardianship and Administration Act in the schedules at the back of the Act. For some I've seen quite detailed reports. So once the area of capacity is contested, that often there'll be psychogeriatric assessments, that might be neuropsych assessments, which can go for several pages and trying to address the particular areas or decision making that's contested. So there are no guidelines currently. It ranges from a one line that the GP can currently do, which is very blunt and doesn't also explain that someone can regain capacity. If someone's had a stroke, for example, they may regain capacity some weeks or months down the track. So it doesn't educate the attorneys when to step in and out. So hopefully these guidelines will be quite a lot more detailed and quite useful. There's also no one particular health discipline that is responsible. So, for example, an occupational therapist often in a hospital might do a mini mental state, which is just a screening tool, but that might be all that people go off for a formal capacity assessment, which once again is inadequate. So more detailed the better. And also advise people that if you're thinking about who to request a capacity assessment from, think about what are the conditions that might be impacting on someone's capacity, whether it's their mental illness, and a psychiatrist would be useful to do an assessment, or it's an age-related condition and a geriatrician would be better placed to do an assessment.
Fantastic. Well, I think that's, oh, no, we've got one more question coming through. So each statement opens up more questions, which is fantastic because this is a really good time to ask them. What should we consider as a sufficient report when instructed to act on behalf of an attorney exercising the power in the EPA?
I suppose that it addresses the concerns or any indications of a lack of capacity, and in particular looks at, is there any underlying condition? Is it a temporary or a permanent lack of capacity, or indicators of a lack of capacity? And are there any things that could be done to assist the person in their decision making, whether it be medication or asking the questions at a particular time of day. So those types of things that are often neglected in a capacity report. But you want to address at least the basic domains of finances, health, and other personal matters in decision making. Be a bit more specific.
Great. Okay. All right. Well, I think that brings us to a close for today's webinar. So I'd like to, on behalf of everyone out there in Queensland and around Australia watching today's webinar, thanks, Karen, for coming along and presenting such an informative and helpful presentation. Hopefully this is really helpful for your clients out there, and feel free to show them that video. It seems like it's a very complex area of law, and hopefully we're looking at some improvements down the track to make it a little bit more fair and safe for people who are essentially appointing attorneys to look after their affairs for them. So thanks again, everyone, and feel free to register for any future webinars that we've got coming up. We've got a few coming up within the next couple of weeks. So see you there. Thanks, everyone.
Thank you.